Well, good morning, everybody. Welcome to this FTB webinar on heritage enforcement. My name is Andrew Fraser-Urquhart, QC. I'm joined this morning by Charles Forrest from FTB. Charles is one of our most talented juniors, does quite a lot of work in this area already, and has some interesting discussions to share with us in due course. Charles, good morning.
Morning, Afi, morning all.
Morning, everybody. Right, so the format for this morning is I'm going to talk relatively briefly about the basic legislative provisions which relate to heritage enforcement, just as a really by way of reminder. And then Charles is going to take over and discuss in some detail the procedures and the tricks of the trade, really, with respect to certificates of lawfulness with respect to heritage matters. Then when he's finished that, I'm going to come back and I'm going to discuss perhaps the most important heritage enforcement case of recent years, really, the Dill decision, which we got in the spring of this year in the Supreme Court. I'm going to take us in some detail through that and some of the implications of that case. And then finally, we'll revert to Charles again, who will talk to us about demolition of unlisted buildings in conservation areas and the particular considerations that arise when doing that. And then we will take some questions, and that we will think will fill us the hour for our webinar this morning. So first of all, then to share screens and get my slides up. And I start with this glorious image of one, or in fact, it's not actually of the creation that was at issue in the Dill case. It's a piece of work by the sculptor whose work was at issue in the Dill case, which we'll hear about in a little while. But it just gives you a flavour, perhaps, of how one might regard some of the issues that arise in heritage enforcement. But before that, I turn really to an introduction, probably a reminder for many of you, of the basic provisions relating to heritage enforcement, all coming, of course, from the Listed Buildings Act 1990 as amended. And the principal, really cornerstone of the legislative provisions is Section 7, the restriction on works of demolition, alteration, or extension if they are of such a manner as to affect the character of a listed building as a building of special architectural or historic interest. So it's the affecting the character of the building, which is the key. And of course, those works are prohibited unless they are authorized. The method of authorization through Section 8 is listed building consent, the application to the local planning authority for listed building consent, the possibility of appeal to the Secretary of State. And of course, as many of you will appreciate, those matters often run in tandem with applications for planning permission and or for conservation area consent, but they're of course different legislative requirements, different legislative routes to securing consent, and different issues, albeit often interrelated, but different issues and considerations. Section 9 is the teeth, perhaps, behind all this, which makes it a criminal offence to undertake the works described in Section 7, either without consent or in breach of any conditions which are applied to a listed building consent. And it's a strict liability offence, which has some relevance for the timescales and overlapping procedures, but it's a strict liability offence and provided only with the statutory defence that if you are doing the minimum works to a listed building which are urgently necessary for effectively reasons of health and safety or to preserve the building, if you do the minimum necessary and provide appropriate notification to the local planning authority that that's what you're doing and why, then a defence exists. But otherwise, it's a very strict regime of criminal control. The enforcement provisions which underlie all of this control begins with the ability of a local planning authority to issue a listed building enforcement notice. Now, you will notice that a lot of these provisions mirror quite closely the regime for control of breaches of planning control. However, there are one or two differences which we'll point up as we go through, but the basic framework will be pretty familiar, even if you're not completely familiar with the listed buildings regime, as I say, because it is so close in many ways to ordinary planning. So first of all, the matters underlying the issue of a listed building enforcement notice, the fact that it appears to the local planning authority that there is a breach of listed building control, i.e. that section 7 is being contravened. And secondly, the decision of a local planning authority that it is expedient to take enforcement action, as we will see in the Dill case, for example. Those conditions of those considerations of expediency can become important. But once the local planning authority decides that it is indeed expedient to issue a notice, it can require the restoration of the building to its former condition. It can require further works to alleviate any harm that is done. And it can require works also to put the building into the position it would have been in had a condition been complied with. If that's the nature of the enforcement notice, a breach of a condition imposed upon a listed building consent, the enforcement notice can require works to put one into the position if that condition had been complied with. So again, you will notice a fair degree of congruence with the powers relating to breaches of planning control, whereby restoring the building is in some ways akin to remedying the breach of planning control. The further works to alleviate the harms of the building akin to the powers to do whatever is necessary to remedy any harm to amenity. Section 39, and we'll come back to the details of the grounds of appeal in a moment, because they are A, of importance, and B, central to the Dill decision in due course. But section 39 sets out the grounds of appeal to the Secretary of State, an inspector appointed by the Secretary of State in most cases, and then the powers on appeal. And those again are as one would expect. They are to uphold the notice, to amend the notice where appropriate, i.e. to uphold it with amendments. But importantly, the Secretary of State on appeal always has the power to grant listed building consent, even if that particular ground of appeal hasn't been pleaded by the appellant. You'll see there the difference to the regime for planning enforcement notices, whereby the ground A appeal has to be specifically pleaded, and obviously that always presents a decision for someone served with a planning enforcement notice, because the fee is much higher if you include a claim for a ground A appeal seeking planning permission for the development being enforced against. In listed building matters, that is always open to an inspector, even if it's not pleaded. And in planning, as you'll know, certain of the powers under grounds F and G are only available following the Court of Appeal's decision in Ahmed. In normal enforcement, they're only available, those powers, if ground A has been specifically pleaded. But in heritage matters, that option of granting listed building consent is always open to an inspector when an appeal comes forward. Under section 42, a local authority can do the works which are called for by an enforcement notice and then charge the building owner or occupier with the cost of those works if they're not done, and then by the building owner, so that the local authority's got a power to step in and do what's necessary. Section 43 establishes, again in like manner to planning enforcement, that if there is non-compliance with a listed building enforcement notice, then that becomes a criminal offence of itself. And of course, the basic criminal offence of doing unauthorised works remains throughout, but the non-compliance with a listed building enforcement notice is also an offence. And then section 44 deals with the effect of granting consent, and perhaps unsurprisingly, the effect of granting consent is that it overrides or renders ineffective from the date of the grant of consent the listed building enforcement notice. What it doesn't do is sort of retrospectively remove the criminal sanction against works which had been done in an unauthorized manner, or it it doesn't remove the criminality for non-compliance with an enforcement notice until such time as the listed building consent was granted. Now, clearly a court would probably take a relatively benign view of things which were done which were subsequently given consent, but nevertheless, as a matter of law and theory, those offences still remain, and of course in appropriate circumstances the court might not take a benign view. So that's very much a fact specific thing, but that is the power under section 44. Section 44A, added by amendment to the Act, again in like manner with planning, allows for the grant of an injunction to prevent an actual, or importantly an apprehended breach of listed building control. We're all familiar with the difficulties and pitfalls and frankly the relative underuse by local planning authorities of the power of injunctive relief. That applies equally in a sense with respect to listed building control. The power for injunction is there. It's relatively infrequently used, perhaps surprisingly, but the power to prevent an apprehended breach is very important and may well be something that in the case of a listed building whose special merits may be lost entirely irrespective of any subsequent enforcement action, the power to use an injunction may well be of considerable importance, and that's something very much to think about within the whole basket of remedies for breaches of listed building control. So that's the basic framework. Now, the last matter of the legislative framework that I'm just going to comment on before handing over to Charles for his first segment is the grounds of appeal. Now, the first is that the building is not of special architectural or historic interest, i.e. it's a building, but it shouldn't be listed or should never have been listed in the first place. It's important to pause there just as a sort of theatrical trailer, as it were, for the Dill case, to note that the assumption one starts with is that if something is on the list, it's a building. There is no power within these grounds of appeal to challenge the issue of whether or not something is a building, and we'll come on to see how that was a central part of the Dill case in a few minutes' time. But within the conventional grounds of appeal, assuming and accepting that it's a building, the first is that it's not of special architectural or historic interest. And then secondly, there are the grounds of appeal grouped together, as I call them, under the basis of no contravention. And again, in like manner to a B and a C appeal in planning, either because the matters alleged haven't happened, just as a matter of fact, the things that are claimed have not done, or that they didn't constitute a contravention. They perhaps didn't change the special architectural or historic interest, or they were in fact permitted. The defense that I mentioned to the criminal liability under section 9, namely that the works done were the minimum that were urgently necessary in the interests of health and safety and the condition of the building, that is rewritten as one of the grounds. Then, as I say, there is an entitlement to appeal on the grounds that consent should be granted, but I put in the caveat, which I've discussed at length already, that that doesn't have to be pleaded in order for the power to reside within the Secretary of State to give that consent anyway. There are requirements, grounds of appeal relating to failures of service, and again, in like manner to planning, they're pretty difficult to get home with in general terms, but they are there. And then there are suggestions that if one can allege that the requirements are excessive or the time period is insufficient to achieve the objectives that the local planning authority seeks, whether that's to restore the building, to alleviate the harm, or to secure compliance, or to put the building into a position it would have been in if conditions had been complied with, conditions on a listed building consent. And then finally, there is the entitlement to argue that the steps required would not actually, as a matter of fact, secure the restoration of the character of the building. So the local planning authority may be seeking to get someone to do things which really just wouldn't put the position right, and that is a ground of appeal which is open. So there we are. That's the broad legislative framework. And with that established, I now turn over to Charles, who's going to talk to us about another part of the legislative framework, the ability to seek certificates of lawfulness. Charles.
Thank you very much, Afu. Hopefully you can all see my screen now, which should be shared with all of you. Great. Well, I'm going to be talking this morning about two topics, but I'll deal just with the first one before handing back to Andrew. The first topic, which I'm going to be discussing, relates to listed building certificates of lawfulness of proposed works. And the first point on that slide is where the relevant law is found, section 26H and 26K in the Listed Building Act 1990 and those regulations made thereunder. This law was brought into force in 2014, so it's a reasonably recent development in the listed building regime law. Obviously, Clopped and Clopped, we're going to be talking about, we're going to be comparing this listed building regime to the regime under the Tcpa 1990. We're going to be doing that a lot during this talk, but the Clopped and Clopped regime under the 1990 Act, Tcpa 1990, is much older. It dates to the early 70s, but the listed building certificate regime is much more recent, 2014. And the second point on the slide is a very important one, and it's section 26H subsection 2, and that says that a listed building certificate provides formal confirmation from a local planning authority that proposed works of alteration or extension, but not demolition, to a listed building do not require listed building consent because they don't affect a listed building's character as a building of special architectural or historic interest. Now, obviously, demolition is not included in that because you can be fairly sure that demolition of a listed building would be very likely to affect that character. So that's not, demolition is not included in this listed building certificate regime. it's only works of alteration or extension. And the intention of this part of the legislation was interpreted in the case of Crown on the application of Republic of France. And what the court said is that the listed building certificate regime offers a procedure to bypass the need for a full application for listed building consent, where the proposed works are relatively minor and do not affect the character of the listed building as one of special architectural or historic interest. So we'll come on to those latter 2 points a bit later. We'll revisit those, but it's important to note those for now, because the next slide we're going to be looking at the difference between listed building certificates and the Clopped and Clopped regime under the Tcpa 1990. These regimes are broadly analogous, but they have some very important differences, and to fail to recognise those differences would be, well, a real pitfall in terms of historic building enforcement. So the first difference listed there, the second point on the slide, is that listed building certificates do not relate to the lawfulness of existing or proposed use, only works. And this is a simple reflection of the fact that listed building consent is only needed for qualifying works, unlike planning permission, which controls material changes of use. So that's the fact that a listed building certificate only relates to works, not use, is a necessary reflection of that fact. But it is obviously an important one. The third point on the slide is that listed building certificates do not relate to the lawfulness of existing works, only proposed works. So in that sense, a listed building certificate is not like a Clopped. It's like a Clopped. You must apply for the lawfulness before you undertake the works, not retrospectively. Now, if you don't apply prospectively, if you do the works before applying for the listed building certificate, well, you can't apply for that certificate. What you should do is you should use Section 8, subsection 3 of the Listed Building Act 1990. And what that does is it gives the local planning authority power to grant retrospective listed building consent. But obviously that consent only is effective from the date of authorization. So it doesn't provide retrospective consent, and therefore the issue of the offence under Section 9 still arises in theory. And obviously what Andrew was talking about in terms of, well, is a prosecution going to be brought for matters which have been regularised by the local planning authority through the grant of listed building consent? Sometimes yes, sometimes no, depending on the facts. But the important point is that for the purposes of listed building certificates, you must apply for that certificate before the relevant works. So it's like a Clopped, not a Clopped, if we're comparing it to the regime under the Tcpa 1990. The fourth point on the slide is that the scope of lawfulness for which a listed building certificate is conclusive proof is much narrower. So I'll just go back one slide just to remind us what a listed building certificate does. It provides formal confirmation from a local planning authority that proposed works of alteration or extension do not require listed building consent because they don't affect a listed building's character as a building of special architectural or historic interest. So that's really the equivalent of saying, I want a Clopped or a Clopped for you to confirm that this does not require planning permission because it doesn't fall within section 55, or because of the use classes order, or something of that nature. So that's what a listed building certificate provides. Going back to this slide, that's obviously much narrower than a Clwyd or a Clopped. What a listed building certificate cannot be used to show is the following, and obviously these are immensely important features of a Clwyd or a Clopped, and the fact that a listed building certificate doesn't certify these as lawful obviously shows that the regime is much narrower. So a listed building certificate cannot be used to show lawfulness through immunity, and that's obviously a very common feature of the Clwyd regime. You say, well, these works have been up for 4 years, or this material change of use took place 10 years ago, and therefore I want my Clwyd because this development is now lawful through immunity. You cannot do that for works to a listed building, not least because there's no concept of immunity from enforcement in the listed building heritage regime. And a number of cases say that, but an important one is Braun and First Secretary of State, paragraphs 12 to 15. So again, that's really just a reflection of sort of a more fundamental point, that there's no immunity in the context of heritage, and therefore a listed building certificate cannot be conclusive proof of any immunity. The second sub-point there is that a listed building certificate cannot be used to show that sufficient works have been carried out lawfully so that development has begun under a granted listed building consent, for the purpose of ensuring that implementing the rest of the listed building consent would not be time expired, and or to check that usually more substantial works would be lawful because they are in accordance with a granted listed building consent. And this point is taken again from that case of Republic of France. But another very common reason why someone might apply for a Clwyd or a Clopped, along with immunity, another very common reason is in order to prevent a planning permission expiring. So it's a mandatory condition on every planning permission that this development must be begun within X number of years, within 3 years. And what a developer or similar will often do is they will carry out sufficient works at the 11th hour, just before the expiry of that 3-year period. And they'll then apply for a Clwyd or a Clopped and say, well, can you confirm that this planning permission has been implemented and therefore is not time expired, and so that if we want to carry on development under that planning permission, that would be lawful. Similarly, it can sometimes be used, someone might apply for a Clwyd to say, or a Clopped to say, well, I've done, say, 50% of the works under this planning permission. I just want to check that what I've done is lawful. And so if I want to replicate it under the rest of the permission, again, that would be perfectly lawful and proper. Well, a listed building certificate does not act in that way. You cannot, listed building certificate consents are like planning permissions, they are subject to a time limit. The works under this listed building consent must be begun within 3 years, for example. You cannot start those works at the 11th hour, for example, and then attempt to use a listed building certificate to preserve your position. It doesn't work in that way. So that's another important respect in which this listed building certificate regime is much narrower than the Clopped and Clopped regime under the Town and Country Planning Act 1990. The final point on the slide is again a very important one, and it's another way, as many of you will know, another way in which someone might use a Clopped or a Clopped is they say, well, I want to undertake these works. Would it fall into one of the classes in Schedule 2 of the GPDO 2015? So would it be lawful because permission has already been granted by the Secretary of State in advance through a development order? And there are equivalents to the GPDO or equivalents to such a development order in the listed building regime. So there's the listed building consent orders, and there are local listed building consent orders. So can you use a listed building certificate to say, or to try and confirm with the local planning authority, listen, I want to do these works to a listed building. Can you confirm that they fall within a class of works in a listed building consent order granted by the Secretary of State? You can't do that. You cannot use a listed building certificate for that purpose, which again is another reason for why the listed building certificate regime is much narrower than its counterpart in the Town and Country Planning Act 1990. So this is a slide on the law relating to making and receiving an application for a listed building certificate, the prescribed requirements of making an application, validating an application, and requests by the local planning authority for further information. That's all contained in Regulation 2 of the regulations which were mentioned on my first slide. And the second point is a point about the flexibility, similar with Cloppeds and Cloppeds under the 1990 Act, which is that a listed building certificate may be issued for the whole or part of the listed building specified in the application, or it may be issued for all or part of the works described in the application. So you can have part approval. It's not just a case of approving the whole application or refusing the whole application. There is the power for the local planning authority to effectively grant a part certificate to the applicant. So this slide relates to if a local planning authority grants a listed building certificate, and what the listed building certificate does is it certifies that works will be conclusively presumed to be lawful if the works are carried out within 10 years from the date of the certificate, and also that the certificate is not revoked. And I'll come on to revocation of listed building certificates in due course, but just dealing with that 10-year time limit, which is an important point. Many of you will know that under a Clopped, there isn't such a time limit, but what it says is that this Clopped will conclusively presume the lawfulness of the proposed works or change of use, unless before implementation there is a material change in any matters going to determining such lawfulness. So common examples will be an Article 4 direction, or an amendment to permitted development rights, or a judgment of the court. So if you don't implement the works or the change of use before any change of circumstance, well, then your Clopped could be vulnerable to being overtaken by events. That doesn't really apply anywhere near as much to listed building certificates because, as I said, the regime is so much narrower. Therefore, any material change of circumstance, that the spectrum of change is much narrower also. So if a local planning authority makes a judgment of, yes, I'm granting you this listed building certificate because we don't think that the works that are proposed affect the character of the listed building, and that judgment is likely to stand for a reasonably long period of time. So that there isn't that scope for a material change of circumstance. But what there is a 10-year stopgap to basically stop abuse of the system, whereby someone might say, right, well, we were granted this listed building certificate 30 years ago. Let's implement the works thereunder. So it's just to stop that kind of abuse. It's just a fairly long backstop of 10 years. And the bottom point on this slide is what one would expect, which is that a listed building certificate does not remove the need to comply with planning or building regulation requirements, which is obviously exactly what one would expect in these circumstances. What happens if the local planning authority refuses to issue a listed building certificate or fails to determine the application within the time limit? Well, as with Cloward's and Clopped's, the applicant may appeal to the Secretary of State. That's under section 26K. You can appeal if your application is wholly or partly refused, is granted in a different form from how it was applied for, or is deemed to be refused where the local planning authority has not determined the application within the time limit. And an important point, incidentally, is the time limit is 6 weeks, not 8 weeks, how it is with Cloward's and Clopped's, so that the time limit for determining a listed building certificate is shorter than for a Cloward or a Clopped. And any appeal must be made within 6 months of the date of notice of the local planning authority's decision, or of the expiry of that 6-week period, or such longer period as the Secretary of State may at any time allow. So the really important point on that is there is a defined legal time limit of 6 months to make your appeal. Many of you will know that for Cloward's and Clopped's, although they recommend that you make an appeal within 6 months, there's actually no formal time limit. In the listed building certificate regime, there is, and the prescribed requirements of making an appeal are set out in Regulation 3, and the inquiry and hearing procedure rules are the same as for enforcement notice appeals, Cloward or Clopped appeals, or listed building enforcement notice appeals. So once you actually get to the inquiry or hearing itself, the procedural rules will be very familiar to many of you who have done those other type of appeals. And again, similar with Cloward's and Clopped's, the test on appeal is the same. The inspector appointed on behalf of the Secretary of State will consider whether any refusal of the certificate was well-founded, or if there was no refusal because they didn't determine it within the time limit, is then consider, well, if the local planning authority had refused this, would that have been well-founded? So the test on appeal is the same as for Cloward's and Clopped's. And the final slide before I hand back to Andrew deals with revocation of listed building certificates and offences under this regime. And it's not uncommon if during the course of enforcement investigations, things might come to light which justify revocation of a certificate or prosecution for an offence. And the law relating to revocation and offence in this context is the same as with Cloward's and Clopped's. So revocation can take place if any statement or document to support an application was false in a material particular, or any material information was withheld, the revocation procedure is the same, really a point of natural justice. Before the local planning authority revokes a listed building certificate, they must give written notice to a number of different parties, the owner, the occupier, and any person who may, in the local planning authority's opinion, be affected by the revocation, and also to the Secretary of State, where the certificate was issued on appeal. So there's that notification requirement, and then the recipient of the certificate, or the recipients of that notification, have 14 days to make representations against any revocation, one would assume. So that's revocation. The offence is really, it's the same as if something has happened which would justify revocation. It's the same grounds, but you then have the requisite mens rea of sort of knowingly or recklessly making a statement that is false or misleading, or with intent to deceive, using any document which is false or misleading in a material particular, or with intent to deceive, withholding any material information. And it's an either way offence, so it can be prosecuted summarily or on indictment in the Crown Court. And that is it so far as listed building certificates go. And I will, before I talk about demolition of unlisted buildings in a conservation area, I will hand back to Afu.
Thank you, Charles. Very interesting and useful consideration of another part of the legislative framework. I'm now going to turn to to a case and to the tangled tale of Mr. Dill and his urns. So let me just get the slides back up. So yes, Dill in the Supreme Court. Now this is a case that concerned two 18th century lead urns which were produced by the Flemish sculptor John van Nost. I wasn't able to find a picture of the urns themselves, unfortunately, so the gargoyle we saw on the front slide of this presentation is the best representation of Mr. van Nost's work that I could find. But nevertheless, in the course of his labours, he produced two lead urns. They rested by their own weight, by gravity, on a limestone plinth, which thereafter rested on a concrete pillar, again, all resting by gravity alone on the ground. Now, they began life in 1725 at Rest Park in Bedfordshire, which in typically British fashion, being in Bedfordshire, was nevertheless the seat of the Duke of Kent. And they were undoubtedly of artistic value and had a prominent role in his dukeship's property at Rest Park. Then in 1939, they were removed from Rest Park and they eventually ended up at Idlicote House, which in due time was inherited by the appellant, Mr. Dill. And there is Idlicote House, a very grand looking place indeed. Now, Mr. Dill obviously was either not a fan of these urns or needed the cash, but they were sold at auction in 2009. And in fact, they sold for about £55,000 and they were taken overseas. They were removed onto the back of a low loader and eventually taken overseas to the buyer's property. Now, the house itself, Idlicote House, was listed in 1966. And the urns, which the court described throughout with the neutral phrase items, which I will adopt, the items were themselves added to the list in 1986. So obviously a long time before they were sold. The decision listing the items couldn't be found by the council in its records and was never produced to the court. and nor could any criteria by which it was decided that these items were buildings capable of being listed as such, again, was ever found. It's also the case, as part of the factual matrix, that there was no evidence that notice of listing of the items, the urns, had ever been sent to the owner, either at the time of listing or subsequently. And it also emerged that English Heritage had been sent notice of the sale in advance, but quite importantly, they hadn't been sent notice on the basis that they had some form of interest or right to object or protection. They were simply sent notice on the basis that they might be interested in buying the things. So they were forewarned, but in a way that didn't really wasn't consistent with any understanding on the part of the owner that he had an obligation to secure consent for the removal of these items. As I've mentioned, they the piers consisted of limestone pedestals on a slab rather than a solid fixed construction on concrete slabs which were simply resting on the ground. So in terms of the criteria of attachment, there wasn't any. And just for curiosity, we see that the urn and the pier together, so the top two bits were pretty sizable, 2.5 meters tall. To the legalities now then, in 2015, so some 6 years after the auction, the local planning authority heard, and they wrote to Mr. Dill requiring that he secure listed building consent. Obviously retrospective. He applied for it, was refused, and a listed building enforcement notice in the statutory framework that we've discussed was duly issued. It was appealed, and the appeal was dismissed. Now, at the appeal, the inspector concluded that the status of the items as buildings had been settled by the fact of the listing and couldn't be considered again. So you'll recall, just pausing briefly, that whilst it is open to an appellant under the statutory grounds of appeal to argue that the building is not of special historical or architectural interest, there's no statutory provision to say, well, these things ain't buildings. And the inspector said, well, because of that, his hands effectively were tied and he couldn't reopen that issue. That's been settled by the fact of the listing. And that's a view that the High Court and the Court of Appeal upheld in subsequent legal challenges by Mr. Dill. They both accepted that the issue of whether or not these items, the urns, were a building, couldn't be reopened, and so there wasn't any consideration of it. And that's the basis upon which the matter ended up in front of the Supreme Court. Now, the Supreme Court said that they were dealing with 2 issues, but in fact, they in effect decided 3 issues. The first was whether or not the inspector could consider, as part of a listed buildings enforcement notice appeal, whether or not the items were buildings or not. And if the answer to that question was yes, so that the inspector did have the power to entertain that as a ground of appeal, then what were the correct criteria to apply? The reason I say the Supreme Court effectively decided 3 issues is that they also considered, for these purposes, the so-called extended definition of listed building, which is contained in section 1.5 of the Listed Buildings Act, as follows. So section 1.5, listed building is a building included in the list, well, obviously, and an object or structure fixed to the building. So again, fairly obvious. But then what's sometimes called curtilage listed buildings, but in fact, it's an object or structure within the curtilage, and I'm not going to delve into issues of what is a curtilage. That's for another time, and wasn't before the Supreme Court in Dill, it was clear that these things, whatever they were within the curtilage. But the extended definition is an object or structure within the curtilage which forms part of the land and has done so since before actually the beginning of planning control, July 1948. And that's what the Supreme Court called the extended definition. Now, again, also relevant to this, of course, is the definition of building from the Town and Country Planning Act, as it were, the main act of the suite of acts from 1990, which includes any structure or erection and any part of a building as so defined. So parts of a building are a building, as concept we're all familiar with working with. So that's the legislative framework. Then much of the subsequent activity is contained within the legislative provisions I've just discussed. We know that an enforcement notice of appeal can include this claim that a building is not of special interest, but not the issue of whether or not it's a building. Similarly, if you're seeking listed building consent, or there's a listed building consent appeal following a refusal by a local planning authority, again, that appeal, we're not covered this because that's not the scope of this talk, but that can also include a claim that the building's not of special interest. And there is also a freestanding power in the Secretary of State to remove a building from the list. But again, that power presupposes that what's being considered is a building. So that was the framework of legislative provisions, none of them, importantly, touching on this issue of whether or not the thing involved is a building. And so that led Lord Carnworth to deal with this first issue in Dill of as can the status of the items, can their status as buildings be raised in the enforcement notice appeal? The judge said that could be dealt with, Lord Carnworth said that could be dealt with, quotes, relatively shortly, close quotes, which is judicial code for it's blindingly obvious. And it was based, he said, on the fundamental principle in a society governed by the rule of law that individuals should have a fair opportunity to challenge legal measures taken against them. A fairly self-evident proposition, you might think, but of course backed by considerable authority. The case that Carnworth relied upon particularly was the case of Boddington in the House of Lords, as was, but it's a fairly clear and obvious legal principle. Now, in response to that, the Secretary of State argued that the ability to judicially review the decision to list in the first place was sufficient protection. And theoretically, of course, one can see what the Secretary of State was saying. The decision to list something as a listed building is dependent upon a decision, in part, that the thing is a building, and that is the administrative decision of a public body. And as such, it is open to judicial review. So clearly the power's there, and the argument about whether something was a building could be played out through a judicial review. However, and this case is quite a good illustration of the point, it's a fairly limited protection in circumstances where there's no obligation to inform the owner of a listed building that the building has been listed. And we see in this case, back the listing was done back in the 1980s, and the owners of Idlicott House weren't told, and there were no documentary records. And of course, bearing in mind that judicial review has to be undertaken in any cases within 3 months, within the planning context within 6 weeks, it's a fairly flimsy protection. Now, the Secretary of State, in raising that argument, however, went on to cite pretty powerful, again, House of Lords authority in the case of Wicks, where a similar type of argument had been run with respect to planning enforcement. And the House of Lords there had decided that the statutory scheme alone would set out what the grounds of appeal could be. It was a comprehensive statutory code, and therefore, because the matters which the Wicks appellants were complaining about weren't covered, then they couldn't be raised. And the court upheld that proposition with respect to planning enforcement, and the Secretary of State, of course, relied upon that in Dill in suggesting that the protection of judicial review was sufficient. The Supreme Court wasn't having any of that. What it said was that the planning grounds of appeal are so wide that they include every aspect. This is Carnwath's words. They're so wide that they include every aspect of the merits of the decision to serve an enforcement notice. And so this lacuna in the listed building enforcement regime, as Carnwath saw it, this inability to raise the issue of whether or not something was a building in the first place, just wasn't there. There wasn't an equivalent lacuna in planning law, and therefore the Wicks authority didn't work. And in fact, the Wicks authority, he thought, rather played for Mr. Dill, because the planning enforcement regime is so wide, the grounds of appeal are so wide, it was said that there was no need for the inspector to have the power effectively to go beyond the statutory grounds. In this case, Carnwath said that there was a lacuna, and therefore the inspector needed that power. The other reason was that there wasn't a particular clear exclusion. There was nothing in the statutory words to say that the inspector couldn't. It was simply the fact that it wasn't listed as one of the specific grounds of appeal. And so with those factors in mind, the judge, as I say, relatively shortly, on the basis that he thought it was pretty obvious, allowed the appeal on the first issue. He also then went on to talk about the extended definition. As I said, the court didn't specifically identify this as an issue, but then proceeded to give pretty clear ruling on it. And the starting point from Carnwath's judgment is, in fact, there is a really rather large number of things in parks and gardens in particular to which this issue might be pertinent. It wasn't just a very narrow technical issue, but actually looking at some of the guidance and some of the listings from historic England, it actually was quite a broad and important issue. And there weren't any clear criteria for the selection and for the decision to consider things as buildings or not. And so therefore there was again merit in the court giving guidance. It was important, Carnwath said, to note that the extended decision doesn't relate in the object becoming a building in its own right. So if something is part of the land, it's not a building in its own right. It simply falls to be treated as part of the listed building in whose curtilage it stands. But this definition between extended definition being treated as part of the listed building and being a building itself had been blurred in official publications. And so again, the court thought it right to correct the position with some guidance. And effectively, the way it works is that you look to the authorities from land law, from those glorious days of law school land law lectures about degrees of annexation and so forth. And for the extended definition to apply, for something to fall part of the definition of listed building through the extended definition, what you had to look for was the method and degree of annexation, first of all, and secondly, the object and purpose of the annexation. And effectively what was said was that if an object was so central to the design of the house or the garden, even if it wasn't affixed to the land, but simply resting as these urns were on the ground by gravity, but if their positioning and so forth was so central to the design of the garden or the park or the house, whatever it might be, that they could be therefore treated as buildings for the purposes of this extended definition, or they would be treated as part of the building, not as a building in its own right, treated as a part of the building for this purposes of this extended definition. The classic example would be something like a statue or a sundial, around which the whole of the rest of the design of the garden had been based. So the central feature of a garden would be a sundial or a statue or whatever it might be. And in this case, in the Dill case, again, that couldn't possibly apply, because at Idlicott House, the house and garden had been designed and built and occupied for some years before these urns arrived on site in 1939. So by definition, the garden could have been designed around them, because they appeared long after the garden had been designed. So they weren't within the extended definition. So that approach fell away. And then, therefore, the court turned to this issue of, given that the inspector could determine whether or not these items were a building, what test should he or she apply? And the court went back effectively to the planning authority, the planning law authorities, for the proper test for a building, starting with the ratings case in Cardiff, and then through the Barvis authority, which incorporated those basic principles into planning, and then to the Court of Appeal's seminal consideration in the Skerritts case. Skerritts, for those of you who recall, was related to a marquee, a large marquee, which was erected for the summer season in a hotel grounds, and the determination was made as to whether or not that could be treated as a building for the purposes of planning control. And the court said there just wasn't any sensible reason not to use the Skerritts tests within the listed buildings context, and that's how the decision went. So for reminder, the Skerritts threefold test, which the Supreme Court now endorses for whether or not something is a building for listed building purposes: first of all, size. Obviously, to be a building, it has to be pretty large, and the sort of rule of thumb, although it's not decisive, but the rule of thumb is that if something can be brought onto the site assembled, it probably wasn't large enough to be a building. But if it has to be brought in pieces and assembled on site, then it is more likely to be regarded as of the size to be a building. The degree of permanence, and remembering that the 5-month summer season was enough in the Skerritts case to be sufficient. And then the degree of physical attachment, and again, spikes into the ground to hold this marquee in place, were sufficient to give the degree of physical attachment to make it a building. Just a couple of points to note. First of all, some degree of movement of the item, which seems a bit odd thinking of it as a building, that it can move, but so it can. In Barvis, the case involved a mobile crane, which was sat on its own little bespoke stretch of railway line of a few yards long, and it could move up and down this track. Nevertheless, the size, the permanence, and the degree of physical attachment meant it was a building. This crane was a building, albeit that it was potentially slightly mobile. And also the issue of these threefold tests are often overlain with a policy imperative, because clearly a decision that something isn't a building takes away any control from the local planning authority, both in planning and listed building regimes. So albeit that there is a test, there's also the possibility for policy objectives to come in and colour the decision. So those were the factors that the court endorsed in Dill. In fact, the outcome was that the case was remitted for rehearing, and there was a great deal of sympathy for poor old Mr. Dill that he still couldn't get a decision out of the courts as to whether or not these urns were buildings or not. The court said there were factors in both directions, albeit that reading between the lines, I think the court thought that they probably weren't buildings, but they weren't prepared to make that judgment. They didn't have the full facts. But there was a strong suggestion from the Supreme Court that, given that these urns were long gone anyway, been overseas since 2009, it really wasn't expedient to pursue the case. And in fact, subsequently, I've had information that the local planning authority took that rather unsubtle hint and are no longer pursuing the matter. So there isn't actually a final adjudication on whether these things were buildings or not. But we now have the test. The takeaways, to use that terrible modern phrase, I mean, I say hard case is bad law. That formula we're all aware of. I mean, it clearly is a potentially wide-ranging adaptation of the grounds of appeal. I mean, the Supreme Court has opened the door for other things other than those listed in the statutory grounds to be argued. Now, whether or not there will be other things that people will choose to bring in, who knows? One never knows until factual situations arrive. But there's a very clear steer that the grounds of appeal are not in fact definitive, and other matters ought to be considered by inspectors if they're pertinent. Now, whether that really is bad law, who knows? But I do think it's worth noting the potential widening of the grounds of appeal that Dill has brought forward. A strong note to heritage authorities to clarify the guidance and the criteria, and clear guidance on the principles to apply. But of course, with just about everything in planning and heritage, it is very much a fact-based exercise, and one will have to just see how the law and the factual scenarios develop. So that is Dill, a very important case for heritage enforcement, both in terms of the particular issue it focuses on, the issue of whether or not things are buildings, but also, I think, in terms of this potential widening of the grounds of appeal. So that's it from me for this morning, apart from when we come to our question session in just a moment. And I will now hand back to Charles, who will take us through some of the considerations relating to the demolition of unlisted buildings in conservation areas. Charles.
Thank you, Andrew. Hopefully you can all see my slide. This is, as Andrew said, the second part of my talk, and it relates to demolition of unlisted buildings in a conservation area. And as many of you will know, a conservation area is an area of special architectural or historic interest, the character or appearance of which it is desirable to preserve or enhance. And obviously in all conservation areas, there will be listed buildings within that area. But in the majority of conservation areas, I would have thought there'll be many, if not the majority of buildings therein which will be unlisted. And so the question is, how do you control development, or how do you control demolition of those unlisted buildings in a conservation area? And there are two ways of doing this, and I'm going to deal with relevant demolition in particular. But before I come on to that, in England, this is demolition of an unlisted building in a conservation area. Relevant demolition requires planning permission because it is development. That's all really leading to a case from nearly 10 years ago, Crown, on the application of Save Britain's Heritage. And not only is demolition of an unlisted building in a conservation area development, but it also requires an express grant of planning permission, because relevant demolition is an exception to PD rights, permitted development rights, in relation to demolition in Part 11. So you cannot rely on permission granted by the Secretary of State under the GPDO in Part 11, Schedule 2. You have to, if you want to demolish an unlisted building in a conservation area, you have to make an express application for planning permission and be granted it by the local planning authority. Obviously, this, as many of you will know, this was once the preserve of conservation area consent. That all changed as a result of that Save Britain's Heritage case, and conservation area consent in England was then done away with in order to avoid duplicate control. There's no point, if it is development and requires planning permission, the quite sensible decision was made that, well, to save people also applying for conservation area consent, we'll just in England do away with conservation area consent, and it's just a matter of ordinary planning control. And that planning control is enforceable in two ways. This is the bottom of the slide. That can be enforced through ordinary enforcement powers for breach of planning control. So that would be issuing and serving an enforcement notice under Part 7 of the Tcpa 1990, and or alternatively issuing a BCN, a breach of condition notice, if that on the facts was justified, or a Section 187B injunction. So those ordinary enforcement powers which are available to the local planning authority, they are equally available in the context of relevant demolition. But planning control is also enforceable through prosecution for a per se offence under Section 196D of the Town and Country Planning Act 1990. So just as with listed building control, you don't require a breach of a enforcement notice or a listed building enforcement notice. You don't require that to give rise to an offence. Obviously, that's still available if the planning authority served an enforcement notice in relation to relevant demolition, and that enforcement notice was not complied with. Well, that offence would arise in the ordinary way. But just as with listed building control, there is this per se offence which is committed, and instead of taking those ordinary enforcement powers, the local planning authority can essentially skip that and go straight for prosecution under Section 196D. Whether and when that will be justified will obviously all depend on the facts and the local planning authority's discretion. But the point is that the prosecution power is there available in the first instance. And that's what I will be talking about in this second half of the talk. So the offence is to fail to obtain planning permission for relevant demolition which has been carried out or caused to be carried out. So if you instruct a builder or someone like that to undertake the demolition, that does not mean that you cannot be prosecuted for this offence. That's the first way the offence can be carried out. The second way is breaching a condition or limitation imposed on a grant of planning permission for relevant demolition. So nothing much surprising there. It's a strict liability offence, as with listed building offences, and indeed with failure to comply with an enforcement notice or listed building enforcement notice. What does that mean? Well, it means that the prosecution do not have to prove, for example, intention, that the developer or equivalent intended to demolish the unlisted building. You don't have to prove that the defendant knew the building was in a conservation area. And whether any retrospective authorization is granted after the relevant demolition is carried out is immaterial. That's in Section 196, subsection 9. Now, again, as both Andrew and I have spoken about, this might affect the discretion to prosecute. It might not be considered in the public interest to prosecute if authorization is retrospectively given, but that certainly won't apply to all cases. There may well still be a justification for prosecuting, not least because the local planning authority might be granting retrospective authorization might be the least bad option. It's well, do we either leave a big sort of hole in our beautiful conservation area, or we grant permission for the demolition and for a facsimile to be erected in its place. The fact that retrospective authorization has been given isn't to say that no harm has been done. It's just, as I said, the least of a bunch of bad options. So really, it will all depend on the facts in that case. Now, there is a defence which the defendant can rely on. And this is, Andrew's spoken about this defence in other contexts. It's one that crops up at various points in the heritage control regime. It crops up in section 9, subsection 3 of the Listed Building Act, and it also crops up in terms of defences to enforcement notices or listed building enforcement notices. And there are 4 elements to the defence. The first, A, is that the demolition was urgently necessary in the interests of safety or health. B, that it was not practicable to secure safety or health by works of repair or works for affording temporary support or shelter. C, that relevant demolition was the minimum measure necessary, i.e. could they have demolished less. Demolition for the purposes of section 196D includes removal of part of a building, so that can be relevant for subparagraph C. And D is that notice in writing of the relevant demolition was given to the local planning authority as soon as reasonably practicable. The burden is on the defendant to prove this defence if it is to be successful, and as always, where the defendant has to prove something in a criminal trial, the standard of proof isn't beyond reasonable doubt. That's the standard which is imposed on the prosecution. The standard on the defendant is the lower standard of he or she must prove this on the balance of probabilities. And the court, so in a trial and indictment, this would be the jury, it must be satisfied of all of A to D. It must be satisfied itself. So it's not a question of the defendant subjectively being satisfied that all of these requirements were met. It's the court assessing it itself objectively. And to help the court, or in the case of indictment, the jury arrive at this judgment, it will often be informed by expert evidence. That will often be necessary, usually a structural engineer or a similar expert, depending on the facts. But if you're a defendant and you're looking to run this defence, really expert evidence is a precondition. And likewise, if you are a local planning authority prosecuting and the defendant raises this defence, whether the defendant is calling expert evidence or not, it really is a very good idea for the local planning authority to do so in order to try and shut out that defence. Sentencing, well, on summary, it's an either way offence, can be prosecuted in the magistrate's court or the Crown Court. A fine can be imposed on conviction in both, and imprisonment on summary conviction up to 12 months, and on indictment it's up to 2 years. Obviously, imprisonment will be very rare. Ordinarily, these things are dealt with by way of a fine, and but the spectrum of how large that fine will be will depend on a number of different factors, and often it will be a very important and at times complicated part of the case as to how large that fine should be in the event of a conviction. There are some statutory considerations. The court must have particular regard to any financial benefit accrued or appears likely to accrue to the person who undertook the demolition or caused the demolition to be undertaken. That's obviously a simple point, that if someone's trying to make money out of committing this offence, well, the court will seek to deprive them of that money. And the court will also have regard to the considerations. It's a listed building case. It's the case of Crown and Duckworth, and the court there set out 3 considerations. The first being the degree of damage to the historic structure. This might not be relevant because, remember, we are talking about unlisted buildings here. But even though a building is not listed, it might still have some heritage significance. It might be locally listed, for example. So if there has been damage that's been done to a historic structure, that's something the court will take into account, notwithstanding the fact that this is unlisted building. The degree of financial benefit attempted to be secured. This is different from that statutory consideration that I spoke about, because a developer might try and secure financial benefit but fail. So the court isn't going to rob them of any financial benefit which has accrued to them, but the court will mark its disapproval of the developer's intent by taking that into account in terms of imposing whatever fine it might impose. And finally, the degree of the defendant's culpability. There's a broad spectrum of culpability. And these things, won't be relevant in the first stage of the trial, but they will be relevant for sentencing. And if you're a defendant and you've demolished a building intentionally, well, it's likely your fine is going to be higher. But if it's just a pure accident, well, I'm afraid that doesn't save you for the purposes of the conviction. But the court will take that into account in determining the quantum of any fine. POCA, which obviously is a large topic in of itself and that I won't be talking about, but that is also an option for stripping the defendant of his benefit. And finally, if the defendant is convicted, in terms of the court arriving as to, well, how much should we fine this convicted defendant, it might be necessary to have a Newton hearing, which often occur when a defendant pleads guilty, not when they're convicted, having pleaded not guilty. Notwithstanding that, the court does have the power to hold a Newton hearing or a Newton-like hearing to determine matters not able to be canvassed at trial. So that would be, for example, your heritage harm. That's in no way going to be relevant to whether the defendant is guilty, but that's something which will be relevant to the fine. The heritage harm that's been committed, that might be contested. The defendant might be saying, well, this building was of absolute no heritage worth whatsoever. The LPA might be saying otherwise. So that can be determined in a Newton-style hearing following conviction. And that is the end of the second half of my talk. So I will invite Andrew to come back in and we will deal with some of your questions.
Yes, thank you, Charles. Very interesting. We've got a little over time, so we can allow ourselves just briefly to deal with some questions. First of all, question I'll start on is from Martin Stevens, who goes back to the beginning of our discussion about the statutory powers and asks, given that the Secretary of State has the ability to grant retrospective listed building consent, whether or not it's pleaded, does this mean there's an obligation on him to do so, or is it merely discretionary? The short answer, I mean, caveat always with the fact that it's dependent upon the facts of any given case. But, and secondly, given that there is no specific case, or at least I'm aware of, on this point. But the answer I would tentatively suggest is almost certainly yes, there is an obligation where a clear and obvious solution presents itself for the Secretary of State to give consideration to it. I say that really for two reasons. The first is that there's authority in a case called Bath that the Secretary of State has to consider whether or not to amend the notice, and therefore the idea of there being an obligation resting on the Secretary of State is already established. But perhaps more pertinently, if one considers the equivalent powers under planning, there's a line of authority starting with a case called Moore and culminating with a case which is dear to me because it's one I won in the Court of Appeal, called Ahmed, which says that if a ground A appeal is pleaded, so the Secretary of State has the power to grant planning permission for something, then he is under an obligation to consider it if it's a sort of clear and obvious solution to the planning problems. And so therefore, by extension, and given, as I've said on a number of occasions, there is no obligation to plead the sort of retrospective application, the deemed application for listed building consent, one would say that yes, there almost certainly is an obligation resting on the Secretary of State in a clear and obvious case, at the very least, to consider whether or not to use those powers. So that's that one. And then secondly, a matter that came in from Jacqueline Skinner, who asked effectively whether there's an equivalent provision to the system of planning contravention notices for use with respect to listed building cases. Again, the short answer to that is that there isn't an exact same provision, in part because listed building consent works slightly differently in the sense that if there are unauthorized works to a listed building, that's a criminal offence under Section 9 from the get-go, and the enforcement regime is a sort of an adjunct. It's a building upon that basic criminal liability, but that has, I think, led the legislature not to include such a provision. However, there are information gathering provisions. There's an entitlement in particular for a local planning authority to secure entry to properties in order to assess whether or not there have been breaches of planning control. So that to answer Jacqueline's question directly, no direct power in the same way, but there are information gathering powers. Now, I think, Charles, we've also had a couple of questions relating to your subject matter from Tom Brooks first, who talks about the practical comparison between an application for a certificate and an application for listed building consent.
Yeah, that's right. I think Tom essentially says, Tom Brooks says, well, how useful are these listed building certificates? Because in his experience, perhaps they haven't been that useful. And I mean, it's a good point. I mean, really, when I say that the listed building certificate regime is much narrower, in a way that's, you could see that as translating that to being, well, much less useful than Clopped and Clopped. But Clopped and Clopped are an immensely flexible and useful regime. And so arguably it's unsurprising that the listed building certificate is less useful than those extremely powerful tools. What listed building certificates are useful for is where you're talking about minor works. This is what the court said in a Crown on the application of Republic of France. You're talking about relatively minor works. And then this also does affect the evidence in support, because in the evidence supporting your application, you have to explain why the works won't affect the character. Well, if the works are relatively minor, obviously that evidence in support you'd think would be quite summary as well, and you wouldn't have to get into the, hopefully it wouldn't be that contested as to the question of whether it affects the character. So how often it will arise, well, who knows, but where the circumstances do arise, where the works are relatively minor, this procedure can be quite useful in terms of the judgment as to what counts as minor works and what doesn't. But obviously, Tom is a heritage consultant, and he'll be able to provide very good advice on whether these works fall into that particular category or not. There's a second question as well from Lee Scott, where he asks, in short, how does the listed building certificate regime interact with the need for planning permission? That's sort of a brief summary of his question. And essentially, it doesn't derogate from the fact that planning control and listed building control are separate control regimes. That isn't affected. So it shouldn't be thought that a listed building certificate derogates from that principle in any way.
Thank you. And then I think we've just had a late entrant to the question stakes from Joe Horton, who asks about the fact that guidance tells us that the status of a non-designated asset can be assessed during the planning process itself, and asks really about the respective weight to be given to that process of assessment and the existence of local lists of non-designated heritage assets, so they don't make it onto the national list but are on a local list. And certainly one would regard that local list as the starting point for the assessment of a non-designated heritage asset. And I think that probably an inspector would be likely to be swayed by the fact that an asset that was coming forward, which was suggested to have heritage interest, hadn't made it onto the local list. And so my inclination would be pretty strongly to say yes, that the fact of listing on a local list already would probably carry a greater weight with an inspector. But of course, that's not to say that on any given factual scenario, given in particular the resource constraints that local authorities are under, that the fact that the heritage of interest of a non-designated, non-locally listed building wouldn't be given considerable weight. It would just be the fact that one would be making the argument that perhaps the weight should be less because it's not on a local list. One or two more coming through. Let's just see whether we've time to take them. And then just one I think I'm going to deal with relating to Dill from Connor Rutledge, who asks whether it would have been more appropriate for the local planning authority to pursue a breach under the object within the curtilage definition. I think the point about Dill was that the court concluded that these weren't objects within the curtilage because they weren't part of the land on the basis of the landlord tests of degree of annexation, i.e. a fixment, well, there wasn't any, and the fact that it wasn't a central part of the design of the garden of the place where the urns were. So I think that just wasn't an option that was open to the local planning authority, as the Supreme Court found. Charles, I don't know whether you've seen the question from Philip Barton, whether you perhaps just like to touch on that.
Yeah, this question relates to where a local planning authority actively encourages an owner to demolish an unlisted building in a conservation area without planning permission first. For example, recommending deletion of a condition preventing demolition. Who has committed the offence and what sanction is there for the LPA? Well, obviously, it's demolition without authorisation. And if you have authorisation, then you wouldn't fall within that. But insofar as it wouldn't be covered by that authorisation, it would then perhaps be in terms of whether it would, because the developer could also technically be prosecuted as the person who acted that. Obviously, that would be relevant to the discretion for bringing a prosecution. But in the first instance, any demolition would be authorised.
Thank you very much. And then just finally, Alfred Williams, and I'm afraid to make this the last question. He asks what happens or what's the remedy if a local planning authority fails to serve a listed building enforcement notice when perhaps they should. And the short answer is, as with any action or inaction by a local planning authority which isn't dealt with by other statutory controls, it would be judicial review. It's quite hard, one would think, to envisage circumstances where a local planning authority couldn't rationally justify their decision not to serve a listed building enforcement notice. But if there were factors which they had improperly considered or material factors to which they'd failed to have regard in the classic public law tests for the court to intervene, one might see circumstances where a court could intervene, but it would be judicial review. That would be the solution. Ladies and gentlemen, thank you very much indeed for your attention. Charles, thank you for your presentations. Interesting and insightful as always. Just a final word to say that this is but one of the series of FTB webinars. We're now after the summer break and we're back up and full throttle on our webinar series. Someone before the summer break described these webinars as the new Netflix, which suggested to me someone who'd been locked down for perhaps too long, but nevertheless, they are a very interesting and we hope informative way of increasing your knowledge and keeping in touch with recent developments. So we hope that we will see you virtually at the next, and all the details, of course, on the FTB website. Charles, thank you. Everyone else, thank you. Good morning, and have a nice day.